Okay. Let's go on the record on cause number 1-95912-9202, Sain LLC versus Abdel Hussein et al. Counsel, make your appearances.
Your Honor, this is Jim Souter of Thompson Co. Cousin Irons, and Farrah Muad is with me. It may be that George Black, who is also in the pleadings, is attending by audio. I mean, without video.
Your Honor, can you, we're actually getting some feedback on our end.
So you need to everybody who's not talking needs to mute themselves. That should end the feedback.
I believe it's coming from Mr. Souter's laptop. I'm going to mute myself.
Okay. Let's go ahead and proceed. Okay. Well, whoever is arguing needs to go ahead and unmute their laptop.
Okay. Well, Your Honor, we filed a, I think you have to mute yours. Are you on mute? Okay. We're just getting really bad feedback.
Yeah, I don't know what's causing that.
I think so. No, I think it's your speaker.
Try now, Miss Ahmed.
Okay.
Nope, still has a problem.
I apologize, Your Honor. Our IT personnel will be fixing that shortly. Maybe this one.
Yeah, I don't know what, I honestly, every time I've ever seen it, always is fixed when you mute everybody, so I'm not sure what's going on.
Okay. Yeah. Well, Your Honor, we filed a motion for leave for our response to summary judgment that was 4 minutes over the mark, and we would like to get that argued if we can, Your Honor.
Is there any opposition to that? That's 4 minutes. If it was just 4 minutes late.
Yes, Your Honor. My name is Razan Hamida. I represent the defendant in this case, and we are the movements for the motion for summary judgment. We oppose the hearing for the motion to leave, and we object to the response being heard during the hearing today. This entire lawsuit, that was brought against defendant, was because of an alleged missed deadline on behalf of my client. So they sued him for an alleged missed deadline, and we had filed this motion in January. So originally our hearing was set for February, and we had agreed under a Rule 11 agreement to push our hearing back 21 days after the defendant was deposed. The defendant, because of COVID-19, had been deposed. The deposition was May 27th. So we agreed to set it 21 days as according to the Rule 11. And in the Rule 11 agreement, and if I have your permission to share my screen, I can show you the Rule 11.
Okay.
Okay. It says host disabled screen sharing.
Let me turn this on just a second.
All right.
There you go.
Okay. So, and this is our exhibit one for our response to plaintiff's motion for leave. Can everybody see this? The document?
Yeah.
Okay.
Yes.
This is our Rule 11 agreement that we had agreed to push our hearing back from February 21st to 21 days after defendant was deposed. We ended up agreeing to having him be deposed on May 27th, which is a month ago. We have also included, and I have highlighted here, that the parties agree that the plaintiff must file its response to defendant's traditional motion for summary judgment no later than 7 days. So on top of the fact that, you know, it is the law and the Texas Rules of Civil Procedure that they must file their response before 7 days, we have also included it in our Rule 11. And this is not just any motion for summary judgment where they had the 21 days to respond. They've had since January to file, prepare a response and have it filed before the 7 days.
All right, the court is going to grant leave. So let's get to the merits.
Okay.
Thank you, Your Honor.
And Your Honor, quickly, counsel for defendant Ready Real Estate, we do not oppose plaintiff's motion.
Okay, great. You don't oppose their motion for leave or motion for summary judgment?
We do not oppose their motion for leave for summary judgment, Your Honor.
Okay.
And this is Jonathan Hernan.
So either turn yours all the way down.
All right, let's proceed, guys.
Okay. May we proceed with the motion for summary judgment?
Yes.
Okay. So would you like a brief description of the facts of this case?
Just get to the kind of what your main argument is.
Okay. So, Your Honor, we represent the defendant, who is a middle-aged Middle Eastern immigrant who has about a 5th or 6th grade level education. He barely speaks English. He entered into a commercial contract with the plaintiff to buy these 2 parcels of land. The seller bought these 2 parcels of land around March 2018. He bought them for about almost $18,000. He went back immediately and sold them to my client for $650,000. This contract, Your Honor, is riddled with improper modifications. There's parts on Exhibit A of our motion for summary judgment, which I'm going to screen share. This is page 9 of Exhibit A, which is the commercial contract. Your Honor, the underlying purpose of this entire commercial contract was that my client would be able to rezone this property for commercial use. It was a residential property, and plaintiffs knew that this was his intent. It was unambiguous, it was clear, he wanted to get it rezoned. This contract, as you can see, there's parts such as, Article 15 for default, where there's certain things that have been crossed out and both parties have initialed. If we go up to even just the page before or the first 2 pages of the agreement, you can see right here under Article 7, there's things that are crossed out with no one initially. You can go up to have on page 2 of the agreement of the commercial contract of Exhibit A, you can see under Article 4, there's things that are crossed out, no one initialed, and then Article 5, there's things that are crossed out and only one party initialed. But the entire crux of this argument is the section for special provisions. And Your Honor, my client did not, so I'm going to get to the section for the special provisions. It's right here, it's Article 12. And we agree that the buyer is responsible for rezoning the property, as it is stated here. If the city of Dallas denies the request verbally or in writing the rezoning to commercial retail within 90 days of execution of contract, buyer can terminate the contract and receive the earnest money less amount indicated in paragraph B1A. And my client went ahead and tried to rezone this property and it was denied. He understood this section to mean that, and I will take you to his affidavit, which is Exhibit B, and let me know if this shows up on your end. Can you see this?
Okay. Yeah.
I have the section highlighted here, and this is Exhibit B of my client's affidavit. And it says, it was my understanding that if I was not able to get the property rezoned to commercial, I would terminate the contract and receive my earnest money back, less a $1,000 fee. He states this on multiple occasions. And as you may know, I'm going to stop screen sharing now. As you know, Your Honor, a contract is legally binding only if its terms are specific and definite and clear in their meanings, and both parties completely understand the same thing. My client, as I stated, understood it to mean that he had the right to have, and he had it preliminarily denied, which is also in I believe the affidavit.
Ms. Hamada, is it correct that the city of Dallas, and this is my understanding, the city of Dallas during the 90-day period did not make any decision one way or the other about the rezoning?
Yes, Your Honor, that's correct.
And so you're trying to use parole evidence to conclusively establish the existence of the contract and the terms of the contract?
No, Your Honor. I think that basically our client did not, so basically the rezoning of the property, he never got a decision within the 90 days. So that's true. After the 90 days, the plaintiffs continued working. So we had our client hired Baldwin and Associates to help with the rezoning. And we have to show that the plaintiffs had continued to.
You need to speak up. I can't, you started being really quiet.
Oh, okay. I was saying that the plaintiffs were continuously working even after the 90-day extension passed, which is their argument is only breach of contract. Breach of contract, and they're asking for specific performance, which is an equitable remedy. When they have still
But
worked,
you're the one moving for summary judgment, not
Yes.
them, correct?
Yes, Your Honor.
Okay. All right. I think I've heard enough probably at this point. Did you want to say anything, Ms. Ahmed?
Yes, Your Honor. Oh, sorry.
Just make it quick.
Yes,
Please.
actually, Judge, Mr. Souter is going to argue.
Your Honor, and succinctly, the movement has filed on a concept that there was not a meeting of the minds. That concept only applies when there's a lack of understanding whether or not a contract has been entered into. Were the essential terms of the contract there or not? And that is the basis for which this motion is presented. Yet, when you have an express contract, which we have here, not oral understandings, not oral agreements, not emails going back and forth, you go to the contract itself, and that's what the contract says. And yes, the plaintiff is trying to use, the defendant is trying to use parole evidence to modify the terms of the contract. The four corners of the contract dictate in fact, Mr. Hussein recognizes in his affidavit the existence of the contract. That's what he's bringing his motion on, and therefore the contract must be upheld exactly as it's written. And basically, Your Honor, Mr. Hussein simply did not notify anybody that there was a lack of zoning, or the city had not zoned within the 90 days. So he now has until the closing dates of March 5th. That's 90 days after that 90-day period. So he can go out and try to find zoning, but if he doesn't get it, that's fine. He has it's his obligation. This is not a contingent clause. It is you may be able to terminate it. You might get your money back less than $1,000. After that 90 days, you got to find a way to rezone, Your Honor, and he didn't do it. And so the plaintiff is asking for alternatively specific performance or return of the earnest money. Your Honor, for that reason, I think the motion should be denied because the plaintiff has, the defendant rather, has not carried their burden on their motion for summary judgment.
I mostly agree with you. My only point would be, I think this contract is kind of ambiguous, so it's probably going to be a fact issue for a jury to decide on what happens after that 90 days, but I'm not ruling on that today. I'm going to deny the summary judgment. Have you submitted an order already?
No, we have not.
Have they submitted an order?
We can, Your Honor.
Okay, go ahead and email that to my court coordinator and go ahead and e-file it. And thank you so much for your time. Mr. Jonathan, did you want to say anything?
No, Your Honor, that's all from our side.
Okay. All right, guys, you guys have a safe week, and just give me a copy of the order, okay?
Take care, Your Honor.
Thank you.
Thank you, Your Honor.
And Mr. Waters, our next hearing's at 3 if you want to come.
Thank you.
All right, thank you. Bye-bye.